Good morning, ladies and gentlemen. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. First of all, I'd like to welcome you to County Court at Law Number 2. You have been asked to come to court this morning for what is called an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Cases are divided into civil cases or misdemeanor cases. Civil cases or criminal cases. The case that you have here is a criminal case. Now, criminal cases are divided into felonies or misdemeanors. The case that you have in this court is a misdemeanor case. The difference between the felony and the misdemeanor, basically, your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. For example, felony cases are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. We have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, then they can be sentenced anywhere from a minimum of 6 months to a maximum of 2 years in state jail. They can be given a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the minimum is 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about that because the offense that you have been charged with is classified as a misdemeanor. Misdemeanor offenses are divided into 3 categories. You have, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is a fine that does not exceed $500. So you cannot get jail time for a Class C misdemeanor. Now, when I say a Class C misdemeanor, those cases that fall into that category are not wearing a seatbelt, speeding, having expired license sticker, so those type cases. And those are the cases actually, they start in the city court or the municipal court or the JP court, which is the justice court. They come to this court when a person is convicted in one of those courts, and then they will appeal their case. In essence, they would like to have a higher court to look at the case to see whether or not, to look at their case so that they can get a whole new trial. And so the case comes here. The punishment range does not change. It stays the same. You only could be given a fine up to $500. You can't get jail time. Now, if you fail to pay the fine, or if your fine was converted to community service and you failed to perform the community service, then they can issue what is called a capers pro fine. In essence, a warrant for you to sit out the fine. And you would have to sit out the fine in jail, and you receive $100 per day credit that will go toward the payment of your fine. So every day you sit in jail, it's $100 that credit that will go toward the payment of that fine. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days or 6 months in the county jail, or a fine from $0 to $2,000, or you could be given both such fine and confinement. The Class A misdemeanor, which is the highest misdemeanor, the range of punishment, if you're convicted, is 0 days to 365 days, which is a year in the county jail, or a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, you may qualify for one of two types of probation. There's one type of probation is called unadjudicated probation. Unadjudicated probation is a form of probation whereby if you get on the probation, you will not have a conviction on your record. And if you complete that probation, you can get what is called a non-disclosure. In essence, your record will be sealed. It cannot be sealed. The general public cannot have access to it. Now, I use the word general public. The general public, that does not include the government. The government can have access. So any governmental agencies, police department, school districts, etc., they can have access. But the general public, which is most of the public, cannot have access to it. So that's called a non-disclosure. Now, the other type of probation is called adjudicated probation. We have unadjudicated probation and adjudicated probation. With adjudicated probation, we call it the regular probation. It does result in a conviction on your record. However, there's something that is called judicial clemency, whereby the judge can set aside your conviction. But in order for that to happen, you have to, one, successfully complete the probation. There cannot be any more time left on the probation. And you have to be successfully discharged off of the probation. If those three things happen, then the court can set aside your conviction. And if the court set aside your conviction, then you no longer have this conviction on your record. Now, if you get a subsequent conviction, that is, if you get another conviction later on for another case, then they can bring this other, the first case back up. In essence, the one you got judicial clemency on, that can be brought back up. It could be resurrected, revived, and brought back up and used against you. If you try to get a license from CPS, they can deny giving you a license, or they can suspend or revoke any license that you have with CPS. Okay. Now, the paperwork that you have, we're going to go over that paperwork. The first document should be titled, well, there's a document on that clipboard that is titled Judge's Explanation of Rights to Defendants Without Attorney. And on that document, it states, as a defendant in a criminal case, you have three options. Number one, and we talked about three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset to give you time to hire the attorney. Now, if you want an attorney, but you do not have enough money to hire an attorney, you would have to fill out a financial questionnaire. Now, the financial questionnaire is a form on that document that is titled Jefferson County Affidavit of Indigence. You would have to fill out the first page and half of the second page of that document so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, the third option is you may represent yourself. Now, if you want to represent yourself, you will have the opportunity to speak to one of the assistant district attorneys in the case. They work for the Jefferson County District Attorney's Office to see if you can work out an agreement to settle your case. Now, you may not speak to the prosecutor or the assistant criminal district attorney about your case unless you first sign a written waiver of your right to be represented by an attorney. The written waiver is also on that clipboard. It is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Once you read and sign that document, you'll have an opportunity to talk to one of the prosecutors to see if you can settle your case. Now, you should be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of that document that is titled Judge's Explanation of Rights to Defendants Without an Attorney, it states, defendant's choice, marking issues next to one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if your choice is to waive your right to an attorney or to give up your right to an attorney, and you would like to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines on the judge's explanation of rights to defendants without attorney, then you will sign your name on the line that is titled defendant, and you will date it today's date, May 21st of 2024. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney and you would like to represent yourself, then you will have to also read and sign the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And I'm going to go over this document with you. And it states as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Now, voluntarily means that you're doing it of your own free will. Nobody's forcing you to do it. Intelligently made means that you know what you're doing. So you're saying that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 21st day of May of 2024 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, May 21st of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. That area over there where there's 12 chairs are, we call that the jury box. 6 citizens will be selected to serve as jurors in your case. And they will listen to all of the evidence, listen to the oral arguments. They will retire to deliberate. And then after they deliberate, they will decide whether to find you either not guilty or guilty of your charge. You also have a right to waive or give up your right to have a trial by jury. By waiving your right, that means that you will not be having a trial by jury. And if you waive your right to have a trial by jury, then your case will come before the court or before the judge in one of three ways. It can come before the judge by way of a trial. In essence, you don't want to have a jury trial, but you want to have a trial where the judge will be the judge and the jury. We call that a bench trial. And the judge will listen to the evidence, listen to arguments. The judge will decide to find you guilty or not guilty of your charges. The next thing, you also have a right. The other way that your case can come before the judge is by way of a plea bargain agreement. It can be either an agreed plea bargain agreement or an unagreed plea bargain agreement. And what a plea bargain is a settlement that you and the state have reached to settle your case. And that's as you and the state have talked, and y'all just you come to an agreement to settle your case. We call that a plea bargain agreement. Now, if you have an agreement, the agreed plea bargain comes before the judge, and then the judge can either do one of two things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. If the judge rejects the plea bargain agreement, then you have a right to withdraw or take back your plea. In essence, you tell the judge, well, judge, since you're not accepting the plea bargain agreement, I take back my plea. In essence, I will not plead guilty, and I will not plead no contest. And you have a right to do that. Now, if the judge follows the plea bargain agreement, accepts the plea bargain agreement, then if you decide within 30 days that you would like to appeal your case, in essence, you would like to hire a court to review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you, then the judge has to give you permission to appeal. If the judge gives you permission to appeal, then your case will leave this court and it will go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. They will review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, and then basically your case will be over. Or they could send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal your case to another court. You can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals. You will have to file what is called a pro se petition for discretionary review. Pro se petition basically means you'll be representing yourself. You won't have an attorney representing you. You'll be representing yourself, and you'll be petitioning the court or asking the Court of Criminal Appeals to review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. Now, they can do one of two things. They can either accept, or they can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty and the case is over. Or they can send the case back to the Ninth Court of Appeals, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your petition for discretionary review, then at that point your conviction will stand. Now, also you have a right to have, I talked about you having a right to have a trial by jury, or if you waive your right to have a trial by jury, you can have a bench trial, just a trial by judge only, or if you could enter into an agreed plea bargain agreement. The other agreement that you can enter into is what is called an unagreed plea bargain. In essence, you and the state have not been able to reach an agreement concerning your case, and you want the judge to decide what your punishment will be. The judge will listen to all of the facts in the case, uh, review criminal records, and decide what punish. And there's some other things that the judge would do to determine what will be an adequate punishment in this case. Now, you also have a right to have witnesses to come to court. Witnesses sit in that chair right there. We call that chair, we call that area the witness stand. And a witness there, what they can do, they can testify. They can testify either for you or against you. If you have an attorney, if you represent yourself, you can ask some questions, or your attorney can ask some questions. We call it either direct examination or cross-examination. You also have a right to waive your right to call witnesses. And when I mean by that is, if you waive or give up the right to call witnesses, that means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case. You also have a Fifth Amendment right against self-incrimination. And with the Fifth Amendment right against self-incrimination, what that means is you have a right not to testify in your case. The government, the state of Texas, the district attorney's office cannot force you to take the witness stand in your case. Now, you can waive or give up your right, which means that you can take the witness stand on your own behalf if you decide to do so by waiving your Fifth Amendment right against self-incrimination. You also have a right to have what is called discovery. Discovery means you have a right to see the evidence that the state has against you. You have a right to have access to the evidence. You have a right to see witness statements, your statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings, or any type of instruments that the state is using or will be using in your case. You have a right to have access to that. Now, you also have a right to waive or give up your right to have discovery. And if you waive or give up your right to have discovery, that simply means that you will not have access to the evidence that the state will be using against you. Jefferson County has a program. Well, first of all, everyone that's here today for court, you have been arrested and you're out of jail. And now you're out of jail because you're out of jail on what is called a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means that you paid a bondsman a percentage of the cash to get out of jail, or you're out of jail on a personal recognizance bond or a PR bond, which means that you did not have to pay any money to get out of jail. You are released under your own personal recognizance with a promise to appear here in court. Now, every day that you spent in jail can be used as punishment, can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail before you bonded out, and you in the state and your attorney in the state have talked, and they are offering for you to serve 5 days in jail. Well, that simply means that you will not serve 5 days in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the 5 days that you have already served. We call that credit for time served. Now, if they are offering 7 days in jail and you spent 5 days in jail, that simply means you will only have to serve 2 more days in jail because you have 5 days credit. So we take 5 from 7, that leaves 2. Every day that you spent in jail also can be used as credit toward your fine and court costs. For every 1 day that you spent in jail, $100 can be used toward your fine, and you'll be credited $100 toward your fine and court costs. So, for example, let's say the state is offering you fine and court costs of $500. You spent 5 days in jail. That means you will not have to pay any more money to get out of jail because you already have $500 credit that will go toward the $500 fine and court costs. If they are offering fine and court costs of $700, that simply means that you only have to pay $200 because we will subtract the 500 from the 700, and that leaves 200. And you'll be required to pay the $200 on the day that your case is disposed of. If you cannot pay the fine and court costs on the day that your case is disposed of, then we can put you on what is called a payment plan. That simply means that you can pay the amount over monthly installments. So for example, you only pay so much each month until the total balance is paid off. Now, if you're unable to pay the balance off, that is, you don't have the money to pay the fine and court costs, even if we put you on a payment plan, no problem, because we can convert the fine and court costs to community service. You will work at a nonprofit organization to work off the fine and court costs. You will receive $12.50 for every 1 hour that you perform in community service. So in our scenario where we say that you owe $200, that's converted. So the $200 is converted to community service. It actually, what that means is you would have to work 16 hours, because 8 hours is $100, 16 hours is $200. So if you work 16 hours, that will pay off your fine and court costs. And basically, 16 hours is 2 days of community service at a nonprofit organization in Jefferson County. Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. If you haven't been in trouble before, the Jefferson County District Attorney's Office, if you qualify for the program, they will dismiss your case. And if you complete the program, you can get it wiped off your record, which means you can get it expunged, deleted, wiped off, or erased from your record. In order to qualify for the program, as I mentioned earlier, it has to be your first time getting in trouble. It has to be an offense. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you with making out the application to get into the program. And again, if you get into the program, you complete the program, case is dismissed, you can get it wiped off your record. Now, Jefferson County also has a program that is called Veterans Court. It's for veterans only. If you're veterans of anyone, if you are a veteran of any one of the military branches, with the Veterans Court program, it's also part of the pretrial diversion program. And with the Veterans Court, only thing you have to do to get in that program is be a veteran. And if you get into the program and complete the program, they will dismiss your case. And you can get it for what is called a non-disclosure. And a non-disclosure, as I mentioned earlier, is where they will seal the record to the general public. The general public cannot have access to your criminal record. And that's for that program is for veterans only. It's called Veterans Court. This court has a program that is called the CSI program. The CSI program is a program that I started in 2017 within the first 100 days of taking office. And that program, it started in March of 2017. And that program is designed to address the issue of what we call recidivism. Recidivism means people commit crimes over and over. So how do we address it? Well, we address it through the Community Safety Initiative. And with the Community Safety Initiative, is designed to make Jefferson County a safer place for all of us to work, live, go to school, raise our families, go to church. And the way the program operates, we have partnership with local agencies. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas region. And what Spindletop will do, Spindletop can address any mental health needs. They will conduct a private interview. They will do an assessment, and they develop a treatment plan for either outpatient or inpatient treatment, depending on your mental health needs. Now, you do not have to be incompetent or insane to be in the program. You can just merely suffer from anxiety or depression or any host of any other mental illnesses. And they have the expertise to address those issues. Now, Spindletop, we have some folks on Spindletop here today. They're going to come to you in a few minutes and tell you more about the program that Spindletop has to offer. Now, Smithers also has a program that is called ATAR. ATAR is a program that is a drug and alcohol recovery program. ATAR stands for Addiction, Treatment, and Recovery. That program is designed to address individuals who may have issues with alcohol or drugs. They will do, and we also have a partnership with Ozar. Ozar is through our local drug and alcohol council program that we have a partnership with, and the Ozar stands for Outreach, Screening, Assessment, and Referral. Both programs, ATAR and Ozar, are drug and alcohol recovery programs, and both can address any problems that individuals have with alcohol or drugs. They will do a screening, a private screening, an assessment, and then they can refer you to either outpatient or inpatient treatment, depending on your needs. If you are unemployed or if you are looking for a better job, we have a partnership with the Golden Triangle Empowerment Center that has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry and the chemical industry. Once you are trained in any one of the areas that you select, they will assist you or help you to get a job in the area that you're trained in. If you have not graduated from high school and you would like to get your GED, well, CICE has a GED program where you can get your graduate equivalency diploma. All of these programs that I just mentioned to you, which is part of the CSI program, are free. It does not cost you anything but time. And in this court, I like to say that we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I tell people this all the time. When you come to county court at law number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, then we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. And so with the programs that we have to offer, it's making Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. Now, the folks in Spindletop is going to come to you in a few minutes, and they're going to tell you more about the program that they have to offer. And then once they come, then we're going to go into recess. And when we go into recess, what we're going to do is we're going to pick up the paperwork that you have on the clipboard, and then we're going to call you up before the bench. We're going to call you up one at a time to go over that paperwork. And either you're going to be put in the category of wanting to hire an attorney, or wanting to apply for a court-appointed attorney, or you might want to waive your right to an attorney and to represent yourself. Now, it's going to take us a few minutes, so it's going to take us a little time to pick up the paperwork and to evaluate it and to go through the paperwork. If you need help with the paperwork, we have our court personnel who's here, who will be happy to help you with that paperwork. Now, as I mentioned, it's going to take us a little time to go through that paperwork. You might want to use the restroom. There are 2 restrooms that are right outside in the hallway. There is the men's restroom, which is in front of County Court at Law number 3, which is next door to this court. And The women's restroom is on the opposite side of the hall in front of the 172nd District Court, okay? So before we go into recess, we have Deputy Hinton, who's here, was from Spindletop. He's going to tell you more about the program that Spindletop has to offer. Deputy Hinton.
Thank you, Norm.
You're welcome.
Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state commission here with the sheriff's office. I also have a qualified mental health professional. She's in the other court, but she will also be available. And the reason we are both here this morning in this courtroom is because the judge cares about every single person who comes before the bench. What the judge has found, and what statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with their situation. Now, this may be your first time to be in court, could be your 10th time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're gonna need something from you. Now, I passed this out earlier. I hope everyone got one. It's the demographic sheet. This is a form where you can actually tell us what your needs are very privately. We'll pick this up shortly. The judge goes into recess, and we'll be able to visit with you at that time, and we'll answer any questions you have. And I'll also use that opportunity to pass out one of these to everyone as well, so you'll have this. It's a flyer. It has some advantages of actually participating on the back, and it also has a 1-800 number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. Just shortly, the court's going to go in recess, and when it does, then I'll be able to come out there. I'll visit with you, answer any questions, and I'll pick up those documents and hand this out to you all as well as that time. Thank you. Thank you, Your Honor.
Okay, you're welcome. Thank you, Deputy Hinton. Now, ladies and gentlemen, as I mentioned earlier, if you need any help with filling out the paperwork, we have our court personnel who's here to help you with the paperwork. And for those of you who might need help with your paperwork, just simply raise your hand, identifying yourself, and then we either come out to you, or we'll ask you to come up here, and then we'll go over the paperwork and help you with that paperwork. So at this time, we will go into recess. Now, I did mention that there are 2 restrooms in the hallway. You can go and use the restroom. When you finish using the restroom, please come back into the courtroom. Do not leave the courthouse. If you leave the courthouse and your name is called, then your bond will probably be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. But do not leave the courthouse. So if you need to use the restroom, you can go use the restroom, and then you can come back into the courtroom. And again, if you need any assistance at filling out the paperwork, just let us know, and then we'll give you the assistance that you need. So at this time, the court will be in the we'll go into recess. Jefferson County Court at Law number 2 is back in session. Court is in session with the arraignment docket on today's date of May 21st of 2024. First case is cause number 23CCCR 1768. The case is filed in the state of Texas versus Allison Latrice Lovelady. Ms. Lovelady, would you please come forward? Ms. Lovelady, your full name is Allison Latrice Lovelady?
Correct.
Mr. Hubel, then you said it was one. Okay. Ms. Lovelady, I'll show you two documents that you signed. Ms. Lovelady, do you recognize this document?
Yes, sir.
And is this your signature online as title defendant?
Yes, sir.
Are these your initials online that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that's titled Affidavit, Jefferson County Affidavit Industry. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes, sir.
Ms. Lovelady, before you sign and initial these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Lovelady, I read your answers. Based on the answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that's appointed to represent you in this case is Attorney Joel Vasquez. Mr. Vasquez will be given information to contact you. You will also be given information to contact him. The court coordinator We'll give you that information. Once you get the information from the court coordinator, you'll be free to go.
Yes, sir.
And you have a blessed day.
Oh, thank you, Judge.
You're welcome. Anaya Sloan. Hmm. Anaya,
Anina,
Anaya.
es considerado.
No, just you could. Okay, this is cause number 23 CCCR 2278. Case is filed the state of Texas versus Nadia Jacques. Is that Jaquay Sloan? Ms. Sloan, would you please raise your right hand? Ms. Sloan, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Sloan, you may put your hand down. How are you doing, Ms. Sloan? That's good, Ms. Sloan. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have a document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes.
Ms. Sloan, Before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge? Ms. Sloan, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Langston Adams. Attorney Adams will be given information to contact you. You will also be given information to contact him. The court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Now, Ms. Sloan, before she gives you that information, and the bailiff is going to hand you a document that is titled Bond Conditions. Do you see that title? Standard Bond Conditions accounting for that law number 2. I'm going to go over this document with you. And it reads as following: following the return of the criminal information in County Court Law number 2 of Jefferson County, Texas, all bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply because that only applies in the DWI case. However, condition number 5 does apply, and condition number 5 states as follows: the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Ms. Sloan, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest, and you'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay. Just have a seat in that first chair by the wall and wait for your name to be called. Next case is cause number 23 CCCR 1914. Case is filed in the state of Texas versus Kevin Wayne Chaney. Mr. Chaney, your full name is Kevin Wayne Chaney. How are you doing, Mr. Chaney? You doing good? That's good. Mr. Chaney, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature online as title defender? Or are these your initials online as state you'd like to apply for court-appointed attorney? I also have another document here that's titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant's Signature. Is this your signature? Mr. Chaney, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Chaney, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you. You will also be given information to contact him. The court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. Next case is cause number 23 CCCR 1876 or 1896. 1896. Case is style of state of Texas versus Damiani Reyes. Dolores Reyes. How you doing, Ms. Reyes? That's good, Ms. Reyes. Your full name is Damiani Dolores Reyes.
Damiani Dolores Reyes.
Okay, Ms. Reyes, please raise your right hand. Ms. Reyes, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Ms. Reyes?
I'm doing pretty good.
That's good. Ms. Reyes, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Or these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
Also, I have a document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
Is this on page 2 of this document? There's a signature above the line that's titled defendant signatures. Is this your signature?
Yes, sir.
Ms. Reyes, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
No, sir.
You didn't understand what you read?
No.
Okay, well, it says first name, you put Damiani, middle initials, you put Dolores. Okay, what did you not understand?
Just the whole concept, like,
The concept?
yes. I'm making monthly payments. I just don't understand.
Okay, when you say concept, what concept? I don't understand what you're saying. You said you didn't understand the concept.
I just don't understand the paperwork.
Okay, well, let me go over the paperwork with you. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Okay, and it states as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Do you understand that?
Yes.
Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Do you understand that option?
Yes, sir.
Number 3, you may represent yourself. That's the third option. Do you understand that option?
Yes, sir.
Okay. And if further states, if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset. Reset means that you'll be given another court date to give you time to hire an attorney. You understand that?
Yes, sir.
Number 3, well, the next paragraph states, if you want an attorney and do not have the money to hire an attorney, you will need to fill out a financial questionnaire. And this is a financial questionnaire that I have in my right hand that you filled out that's titled Jefferson County Affidavit of Injuries, so that the proper person can determine whether or not to appoint an attorney to represent you. The proper person that they're talking about in this case is me. So I look at this document, and based on the answers in this document, I will determine or decide whether or not you qualify for a court-appointed attorney. And if you do qualify for a court-appointed attorney, then I will appoint a court-appointed attorney to represent you. You understand that?
Yes, sir.
All right. Now, the next paragraph states you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Now, if you were waiving your right to have an attorney or giving up your right to have an attorney, you will have an opportunity to talk to one of the 2 prosecutors that's sitting at the table behind you. But because you are requesting a court-appointed attorney, this doesn't apply to you. Okay? The fact, because you're not waiving your right to an attorney. So since you're not waiving your right to an attorney, you will not be talking to those 2 prosecutors. If you qualify for a court-appointed attorney, your attorney will talk to the prosecutors on your behalf. Do you understand that?
Okay. Yes, sir.
Now, and you didn't choose to proceed without an attorney, but if you wanted to represent yourself, you had to be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you in your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status, put down citizens and employment. And this doesn't apply to you. Well, it applies in all cases, but your attorney will tell you when your attorney advises you, your attorney will tell you about the consequences of pleading guilty or no contest. Okay, you understand that?
Yes, sir.
Now they said if you would have chosen to proceed without an attorney, then you would have had the option to request an attorney at any point. You could have said, well, Judge, I didn't want an attorney, but now I want an attorney. Okay, do you understand that? Okay, now at the bottom of this document, there was 5 choices that you could have made. You selected the 3rd choice that said you were requesting a court-appointed attorney. And is that correct?
Yes, sir.
So you understand, and is this your signature on the line that's titled defendant?
Yes.
And these are your initials on the line that state you'd like to apply for a court-appointed attorney, is that correct?
Yes, sir.
Okay, now, next document that I have is titled Jefferson County Affidavit of Indigence. Do you recognize this document? This is a document that have your information as to your name, your address, your date of birth, and also it has employment information as well as income information. Now, let me do this here. I need to go over a question with you on this here document. And these are your expenses on this side, is that correct?
Yes, in total.
Okay, so now, let's see. On the back of the document, we just have your signature or a signature that purports to be yours. Is this your signature?
Yes, it should be.
And it has your name, date of birth, address, the county, today's date. So is everything on this document true?
Yes, sir.
Now, is there anything else on this documents that you did not understand?
No.
So is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Ms. Reyes, I read your answers. Based on your answers, you meet the you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you. And you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you will be free to go.
Sir.
And you have a blessed day. Please have a seat in that first chair on the wall.
Do I leave in the back? Wait.
Yeah, yeah.
Hold on. Do I leave?
Just follow her direction. She, next case is clause number M323-160, case of style of state sex was Kyrie Jacoy Williams. Mr. Williams, your full name is Kyrie Jacoy Williams.
Yes, sir.
Mr. Williams, would you please raise your right hand? Mr. Williams, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Williams, you may put your hand down. Okay. Okay. Mr. Williams, did I swear you in already?
Yes, sir.
Okay. Now, Mr. Williams, I have before me a couple of documents. The first document is titled Jefferson County Affidavit of Judge's Explanation of Rights to Defendant's Without Attorney. You recognize this document?
Yes, sir.
And is this your signature online as titled defendant?
Yes, sir.
Are these your initials online state you'd like to apply for court-appointed attorney?
Yes, they are.
And I have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled defendant's signature. Is this your signature?
Yes, sir.
Now, Mr. Williams, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Williams, I read your answers. Based on your answers, you do not meet the qualifications for the appointment of a court-appointed attorney unless something is wrong in this. Mr. Williams, I'm looking at your affidavit. The bailiff is going to hand it back to you. Your affidavit of indigence. I'm going to go over this document with you. I'm going to get off of YouTube. Mr. Shaw, would you please raise your right hand? Mr. Shaw, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Mr. Shaw, you may put your hand down. How are you doing, Mr. Shaw?
I'm doing fine.
That's good. Now, Mr. Shaw, I have before me, let me see, Charles and Shaw. Mr. Shaw, let me ask you a question. I see your middle name is Edward. Your father's name is Ed,
Yes, sir.
okay? Your mother's is Gail Shaw, something like that?
Correct.
Okay. Now, Mr. Shaw, I don't think you and I have ever met. If we've met, how old are you?
35.
Okay, if we met, it probably been over 30 years ago. Because I think I know your parents. Shaw, they teach in the BISD school system?
Yes, sir. We actually met maybe 10 years ago.
10 years ago, okay.
Yes, sir.
Okay, I don't remember that, okay.
You don't remember?
What was that encounter? Was it at a function or just
Basically, I had a criminal case going on, and you were not able to visit my thing because of relation.
about 10 years ago?
Yes, sir.
You said I was not able to visit what? What do you mean?
My case,
You mean I wasn't able to handle the case or I
Yes,
wasn't
sir.
able to,
because you knew of my
Yeah.
family.
because I knew your family?
Mm-hmm.
Or was that a case in city court or what was that? 10 years ago.
County.
Here?
Yes, sir.
I haven't been here 10 years, so,
Jefferson County.
okay.
Maybe
Now, let me ask you this here.
maybe
Was I as a judge or as an attorney or what? What do you?
You were a judge at the time, maybe not 10, maybe 9 or 8.
I haven't been here that long either. I've been here 7. So it came before me on that case? I don't,
7 then perhaps, maybe 2016.
2016 was when I started. In
Oh,
December,
really?
in December of 2016.
Right then.
But I don't think I had any cases. We didn't start having cases back then until like 2017. So
Just
you,
some recollection.
okay, so could have been 2017.
Right.
Let me do this. I'm trying to remember. What happened on that? I'm not necessarily what happened with your case, but well, the case came to this court?
If I recollect, it was, I got off probation in 2015.
Okay, hold on a minute. Let me see if the state can find something. State, do you think there's a conflict of interest? If there's a conflict of interest, I'll be willing to recuse myself from the case.
State knows there's no conflict of interest.
So you waiving any conflict of interest?
Yes, Your Honor.
Okay, no problem. All right, now what we're gonna do next, we're gonna proceed. Now on this, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Show, Ms. Bailey, could you show him this document?
Sure.
Do you recognize that document?
It's a refuse for what?
No. The title is titled Judge's Explanation of Rights to Defendants Without Attorney. That means that you don't have an attorney, and so I explained to you on that document your rights to an attorney. You recognize that document? Is that your signature on the line that is titled defendant? Or those are your initials on the line that state you would like to apply for a court-appointed attorney? Okay, now I also have another document here that is titled at Jefferson County Affidavit of Indians. Do you recognize that document? On page 2 of that document, at the top left-hand side, there is titled, there's a signature above the line that is titled defendant signature. Is that your signature? Okay, you can hand me that document back. Now, before you initialed and signed these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Shaw, based on your answers, let's see. You meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be representing you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will also be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Now, before she gives you that information, I have some bond conditions that we need to give to you. And these bond conditions are being handed to Bailey. And I'm going to go over these bond conditions with you. And it is titled Jefferson County Affidavit, Jefferson, it's titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yeah.
I'm going to go over these bond conditions with you. Any reasons follow. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yeah.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yeah.
Condition number 3, let's see, does not apply because, and condition number 4 doesn't apply. Condition number 4 only applies in the DWI case. In this case, is not a DWI case. Now, condition number 5 does apply, and it says that you will obtain and participate in the Spindletop ATAR, that's Addiction Treatment and Recovery Program. And do you understand that condition?
Will obtain,
Obtain and participate in the Spindletop ATAR Addiction Treatment and Recovery Program. Do you understand that condition?
Yeah.
Okay, and condition number 6, remain drug and alcohol free. Do you understand that condition?
Yeah.
And condition number 7, participate in the ASAP program with Spindletop. And Spindletop is located at 2750 South 8th Street, Beaumont, Texas, Building C, 77701. Do you understand that?
Yeah.
Okay. Now, Mr. Shaw, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes.
Yes.
It says I had to report to Spindletop.
You will participate in that program. You're gonna, I guess when you first go there, they'll do an intake, okay? And then they'll decide whatever the program they think you need to be in, if they think you shouldn't be in any programs, or it all depends on what they determine in the screening or the interview, okay? All right. Now, you're gonna have a seat in that first chair. The bailiff, our court coordinator is gonna do your paperwork, and when she finishes with your paperwork, she'll give it to you. Once you get your paperwork, you're free to go and you have a blessed day. All right. Because Vasquez was already on her case, on Lovelady's case. It's not 2 different cases. I mean, it's different cases, but you know how when we appoint, they only get,
Oh, that one was disposed of, but they found it later.
it's not disposed of. Oh, it was? Oh, I didn't know that. Oh, I thought they said he was still on the case. No, he said there was a case on the docket. There was the case that wasn't on, there's a case that she had that's not on the docket. Yeah, and your full name is Ruby Goosey?
It's Gossy,
Goosey.
yes,
Okay, how you doing, Miss Goosey?
sleeping,
You a little sleepy? Other than that, you fine?
yes, sir.
Okay. Miss Goosey, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God?
Yeah, yes, sir. Uh,
Miss Goosey, Miss Goosey.
yes, call
Uh,
me Ruby,
Ruby,
yes, sir.
okay, Miss Ruby. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney.
Yeah,
Do you recognize this document?
mhm,
Is this your signature on the line that's titled Defendant?
yes, sir.
Are these your initials on the
Yes.
line that's titled,
Mhm.
that states that you like to apply for a court appointed, well, that state
No,
you would
no.
like to
no.
waive your right to an attorney and represent yourself?
Oh, yeah,
Okay. I also,
I'm guilty.
okay, we hadn't got there yet, but we're gonna get there. All right.
They not watching this on TV, are they?
Yes,
They
there.
watching me on TV?
Yes,
Oh,
ma'am.
shit.
Oh, now, Miss Ghosty, let me tell you,
Me-
hold on, you
me-
can't,
me
now,
too.
let me do this here.
Okay.
If you, I'm
For
gonna,
real though, is they watching this or they don't on TV?
yeah, but let me finish what I was gonna say.
Okay.
If you curse in here again,
Okay, ooh.
we're gonna hold you in contempt of court
Yes, sir.
and we're gonna send you to jail,
Oh, no, not today.
okay?
Okay,
Okay, so that's your first and last one,
yes, sir.
okay?
Yes, sir.
All right. Now, Miss Ghosty,
Yes, sir.
I also have before me a document that is titled Waiver of Counsel for Purposes of any guilty plea or proceeding to trial. Do you recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes.
Ms. Ghosty,
Mhm.
before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes,
Is everything in these documents true and correct to the best of your knowledge?
yes.
Now, Ms. Ghosty, I read your answers. Based on your answers, we'll have a prosecutor from the district attorney's office gonna come out and talk to you about your case. So you can have a seat and they're gonna come out and talk to you to see if you can work out a plea bargain agreement on your case. All right?
Okay,
Just have a seat. Next case is M319526. Case is styled the state of Texas versus Keitha DeJuan Jones. Mr. Jones, your full name is Keitha DeJuan Jones.
Yes, Your Honor.
How you doing, Mr. Jones?
Pretty good.
Okay, Mr. Jones, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely.
You may put your hand down. How are you doing?
Pretty good, sir.
That's good. Now, Mr. Jones, I have before me a document that is titled Jefferson County Affidavit, that's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, Your Honor.
Is this your signature on the line that's titled Defendant?
Yes, Your Honor.
Are these your initials on the line that state you want to waive your right to an attorney and represent yourself?
Yes, Your Honor.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled Defendant?
It is indeed, Your Honor.
Mr. Jones, before you signed and initialed these documents, did you read the documents?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And is everything in these documents true and correct to the
Yes,
best of your knowledge?
yes, it is, Your Honor.
Mr. Jones, I read your answers. We'll have someone from the district attorney's office that's gonna come out and talk to you. Just have a seat.
Yes, sir.
All right. Next case is cause number 23CCCR 1942. Case is styled the state of Texas versus Clifford Lawrence Williams Jr. Mr. Williams, your full name is Clifford Lawrence Williams Jr. Mr. Williams, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Williams, you may put your hand down. How are you doing, Mr. Williams? That's good. Now, Mr. Williams, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Sir.
Or these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or proceeding to trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line inside the defendant?
Yes, sir.
Mr. Williams, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Williams, I read your answers. We'll have one of the prosecutors that's gonna come out and talk to you in a few minutes. Just have a seat, and one of the prosecutors will talk to you.
Right.
All right. Yep, it's coming down the pipe. Okay, so we're back on the record and calls number M 323-160, case of style of state of Texas versus Tyree Williams. Your full name is Kyrie Jacoy
Yes, sir.
Williams. Okay, now, Mr. Williams, you was previously sworn in, is that correct?
Yes, sir.
Now, I'm showing you this document that I showed you earlier. You made some changes. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Williams, before you signed and initial both of these documents, the judge's explanation of rights of defendants without attorney and Jefferson County Affidavit of Indigence, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Okay, now, Mr. Williams, based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you the information, you'll be free to go, and you have a blessed day. Now, before she gives you that information, we need to give to you some bond conditions. Okay. Ms. Bennett? Okay. Did you give him some, did you hand these bond conditions to Mr. Williams? Uh-oh. I went to take this off and it tore. Let me do this.
Yeah, I don't have no glue in my pocket. I carry everything else, and I don't have no glue. I don't have glue.
Let me do this here. You have some tape? All right. Now, Mr. Williams, the bailiff just handed you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? I'm going to go over this document with you and it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, The defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and test in the case of presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Question. So I'm not allowed to go like to a bar or anything?
Let me read this again. Just listen to what I said.
Yes, sir.
The defendant shall not, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. So if the court orders you to take a test for drugs and alcohol, you're required to do. The court may revoke the bond and order the arrest of any defendant who, one, or who A, refuses to submit to a test for drugs and alcohol when directed to do so. So if you court orders you to take a test and if you refuse, the court can revoke your bond.
Gotcha.
Or B, submit to a test for the drugs and alcohol, and the test indicates the presence of drugs and alcohol in your body. So if the court orders you to take a test for drugs and alcohol, if you refuse, your bond can get revoked, or if you take the test and you test positive for drugs and alcohol, your bond can get revoked. You understand that?
Yes.
Condition number 3 does not apply. Condition number 4 does not apply because that only applies in the DWI case. However, what was his address? No, you said he didn't have his address on it. Let me see. Oh, he lives in Houston. Okay. I'm gonna have to give him some more different bond conditions. Head. Understand. Okay. Let's see, some different bond conditions. I didn't realize you lived out of town.
Yes, sir. Can I put a couple more phone numbers on there?
She said that.
Just need a number one. It's a valid number, is it? Valid number?
Yeah, it's mine.
Okay, here we go. Okay. I'm gonna have to give him this here. I'll just read it to you, then we'll get you a copy. And I'll just start at the B. Yeah, we're gonna shred this. This document is titled Standard Bond Conditions in County Court at Law Number 2. Following return of criminal information in County Court at Law Number 2, all bail bonds executed for release of any defendant named herein shall or ordered subject to the additional condition, number one, the defendant shall commit no offense against the laws of this state or any other state or of the United States. Do you understand that condition? Condition number two, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol. The test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Sir.
And condition number three does not apply, and condition number four does not apply. However, condition number five does apply. Condition number five states the defendant shall attend AA/NA meetings 2 times a week and provide proof to the court. Do you understand that condition?
Must attend what meeting?
AA/NA meetings, alcohol anonymous, narcotic anonymous meetings. Okay, and I just have this. You should be able to go on the internet and find some locations in Houston. I have some locations in Jefferson County, which is not going to be convenient for you because you don't live in this county.
Right.
Okay, but they have AA all over. Okay, and I'm sure they probably have more locations in Houston than they have here. Okay, so you have to attend those meetings twice a week. I have a sign-in sheet that when you go, a sponsor will sign it indicating that you were present at the meetings. You need to get this document signed by the sponsor. When you come back to court, you have to present this to the court, okay?
So I have to go twice a week until my court date?
Until your case is over. Okay? Not just till your court date. Okay? Do you understand that? While you're on bond, you have to attend AA/NA meetings. All right, now, do you understand these conditions?
Yes, sir.
If you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. You can have a seat, and before you leave, she's gonna give you a reset and a copy of your bond condition. Yes, you had your hand out.
Will I be able to choose what days I'll go on?
Yeah, 2 times a week, yeah. I mean, yeah. What I need you to do is, this is my original. So you have to make a copy, several copies of the original. And then I'll write his name on one. Okay. All right, you can have a seat in the chair on the wall. All right, you're welcome. Okay, ready on? Are you ready on that? Are you ready on anybody? Okay. This is, do we have all of the paperwork? Oh. Okay, here we go. Who else? Okay, here we go.
Starting when do I have to go? When that's my first day?
Okay. This is your first day of this week. Okay. So you can go anytime within twice during the week. Yes, you started your bond conditions start immediately. Once we give you your bond conditions, that's when it starts. Okay. I'm sure you'll be able to find something on the internet. Because they have locations throughout the city. I'm sure they probably have them 7 days a week. Jefferson County Court at Law number 2 is back in session. Court is in session and calls number 23CCCR 1970. Case is styled the state of Texas versus Ruby P. Gosi. Ms. Gosi, you can come forward. Ms. Gosi, full name is Ruby P. Gosi, is that correct?
Yes, sir.
Ms. Gosi, would you please raise your right hand? Ms. Gosi, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Ms. Gosi, you may put your hand down.
Okay.
Ms. Gosi, I have before me a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. On this information sheet, it alleges that you, Ruby P. Gosi, on or about August 25th of 2023, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of failure to identify fugitive intent to give false information. Do you understand what you've been charged with?
yes, sir.
To this charge, how do you plead guilty? Not
Guilty,
guilty.
yes, sir.
Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Ms. Gosi, I also have before me a document that is titled misdemeanor plea admonishments. It's also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there are a set of initials on a line, on 2 lines. The first set of initials is on a line next to a box that says check guilty. Did you
Yeah.
place your initials on this document?
Yes,
On the second set of initials are on a line below a paragraph next to a statement that reads, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest.
yes,
Did you place your initials on this document?
Yeah.
On page 3 of the same document, there is a signature above the line that is titled defendant. Is this your signature?
yes,
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
yes,
And is this your signature on the line that's titled defendant?
yes,
At the top of this document, there are 2 boxes that says check. The first box says check, states that this is a plea bargain case and you have no right of appeal. You understand that statement?
yes,
The second box says check, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
yes,
I also have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
yes,
Is this your signature on the line that's titled defendant?
yes,
Or are these your initials on the line that state you like to waive your right to an attorney
yes,
and represent yourself?
yeah,
And also, I have another document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or proceeding to trial. Do you recognize this document?
yes,
And is this your signature on the line that's titled defendant?
yes,
Ms. Gosey, before you signed and initial all of these documents that I just showed you, did you read the documents?
yes,
Did you understand what you read?
yes,
Is everything in these documents true and correct to the best of your knowledge?
yes,
Ms. Gosey, are you a citizen of the United States?
Yeah, for state.
Now, Ms. Gosey, the state is offering State's Exhibit Number 1. State's Exhibit Number 1 is the document that is titled misdemeanor plea admonishment. It is also the document that have your initials on these 2 locations that you acknowledge were your initials.
yeah,
And this document also have your signature on
Yes.
page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yeah.
Okay, no objection. State's Exhibit Number 1 will be admitted. Now, Ms. Gosey, is there any evidence that you are currently mentally incompetent to stand trial? I'm just asking you a question. This is a question I have to ask.
No, I've got my mind. Last time I checked, I had it. I don't know if it's still there. I'm kind of sleeping at home, but I think it's still there.
Okay, see,
I'm 70, so it might not all be there.
well, now,
It's
Miss-
there.
okay, so you understand why you're here?
Oh, yeah.
And you understand what the case is about?
Yes.
Okay, and you understanding that you entered a plea of guilty to this charge?
Yes.
All right. Now, Ms. Gosey, also I forgot to mention
Oh, wait a minute.
that you had a right to have a court reporter to type down everything that you say, or you could waive or give up your right to have a court reporter.
I
You
think I
waive?
remember like you remembered all that stuff.
Okay,
And that's a lot of stuff you remember.
well, yeah, thanks. But do you waive your right to have a court reporter?
Yes.
Okay, now, Ms. Gosey, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
Yes, Your Honor.
And what is the agreement?
State has offered 3 days jail with 3 days credit if they jump their plea, court costs, tax and retirement in this case.
Okay, what's the court cost?
I
Okay,
have a whole lot of
Mr.
stuff to remember. Y'all say that stuff all day long, every day.
All day, every day. Okay, now, Ms. Gosey, the state is offering that you serve 3 days in the Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you've already served 3 days in the Jefferson County
A
Jail.
whole bunch of days in jail.
Okay. And also, the court cost in this case is $277, but you will not have to pay the $277 because the time that you spent in jail has already paid it off.
Thank you, Lord.
And that's
Thank
now, so
I hate to
therefore.
go to the pawn shop today.
Okay, so therefore, the court costs will be taxed and retired, so you will not have to pay any court costs, and you will not have to serve any more time in jail. Now, Ms. Goldstein, do you understand the state's offer?
Yes, I asked her to go somewhere and sit down.
Okay, do you think that the state,
Yes, sir.
do you think that the state's offer in your case is fair and just?
As long as they don't show that on TV at home.
Well, it's on television.
Oh, shit. Ooh, 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 ooh,
You sound like, Ms. Goldstein, sound like
Oh,
you want to spend some more time in jail.
Oh, nah, no, I want to go home. My mouth is true.
Well, you control your mouth, Ms.
Yes, I stopped that. I stopped it.
Okay, so Ms.
I don't want no
Goldstein,
trouble. I want no trouble.
well,
I
your friend over there,
I see
the
she
bail-
creeping over
the
here.
bail is-
Still, her and her other bro down over here.
yeah, she
I
ready
see her
to,
creeping.
they ready to put you in jail, okay?
Yeah, ain't happening today.
Well, that's not up to you.
I-
That's not your decision,
I'm-
okay?
Yeah,
That's the court's decision because the court
Yes, yes.
had already
Listen.
warned you,
yes,
okay?
yes.
Okay.
Can I go?
Well, I don't know, Ms. Goldstein.
Can you speed it
you-
up so I can
no,
go before I get
you-
myself in trouble?
That's why I'm taking my time.
I know you set me up. You set me up. Set me up. It seems like I'm just falling right on in it.
All right, Ms.
Please,
Goldstein.
Jackson, don't show that on
Okay,
TV.
okay, Ms. Goldstein.
Please let me
The
go
court
home.
is going to, no, the question that I asked, do you accept the plea bargain agreement?
Yes, sir.
Okay, the court is going to follow the plea bargain agreement that you've entered into with the state. Ms. Goldstein, you're gonna stand next to the bailiff, follow her directions, and once you finish following her directions, you'll be free to go, and you have a blessed day.
Yes, you too, Judge.
Okay. Okay, Jefferson County Court at Law number 2 is back in session. The court is in session and calls number M319526. Case is filed with State of Texas versus Keitha Dewan Jones. Is that correct?
Yes, sir.
Mr. Jones, would you please raise your right hand? Mr. Jones, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Jones, you may put your hand down. Mr. Jones, you have a right to have a record. That is, you have a right to have a court reporter to dictate or type down everything that's being said. You also have a right to waive or give up your right to a record. Do you waive or give up your right to have a record?
I will waive my right.
Okay. Now, Mr. Jones, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Keitha Dewan Jones, on or about February 24th of 2018, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of theft of services. Mr. Jones, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, Your Honor.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, Your Honor.
Mr. Jones, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, Your Honor.
This document is also labeled as State's Exhibit number 1. On page 2 of the same document, there are 2 sets of initials. One set of initials are on the line next to the box that check no contingent, which means no contest. Did you place your initials here?
Yes, Your Honor.
The second set of initials is below a paragraph that is titled Discovery Admonishment and is next to a statement that reads as follows. I do not request discovery of the evidence. I've waived my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir, it is.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled?
Yes, sir. Yes, Your Honor.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, Your Honor.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, Your Honor.
I also have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled Defendant?
Yes, sir, it is.
Are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Yes, sir, it is.
I have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir, I do.
And is this your signature on this document?
Yes, sir, it is.
Mr. Jones, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir, I
Did
did.
you understand what you read?
Yes, sir, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir, it is.
Mr. Jones, are you a citizen of the United States?
Yes, sir, I am.
State-
State offer states 1.
Mr. Jones, the state is offering State's Exhibit number 1 to be used as evidence in your case. State's Exhibit number 1 is the document that you acknowledge that these were your initials on the 2 locations on page 2, and this, you acknowledge that this was your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Absolutely.
No objections. State's Exhibit number 1 will be admitted. Mr. Jones, are you a citizen of the United States?
Yes, sir, I am.
Okay, I think I asked that already. Now, Mr. Jones, is there any evidence that you are currently mentally incompetent to stand trial?
None, Your Honor.
Okay, Mr. Jones, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor, we do.
And what is the agreement?
In exchange for defendant's plea of no contest, the state's offering 90 days probated over 1 year 40 hours community service, the state will be waiving the fine, and restitution is to be paid in the amount of $919.69 to Wayne Allen Cureton. The defendant will also be required to take a fetch class and court cost.
What's the court cost? $337.
So I think like, when will, like, I actually, be, start my probation? Like,
Today?
Information and you'll go to the court.
today?
It starts today.
Yes, ma'am.
Do you still live in town? If you
Um,
don't live in town, they could transfer it to the county that you live in.
I'm working out of town.
Oh, so you still live here, okay.
I still live here, but I'm working
Okay.
out of town, so I don't know if.
You just tell them that they'll,
Tell your sir.
yeah, they'll
Just report.
work around that. Okay, now, Mr. Jones, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail in this case, because you'll be placed on probation for 1 year. During the 1 year probationary period, you will not be required to pay a fine. That fine will be waived. You will be required to pay court costs in the amount of $337. You'll be required to pay restitution in the amount of $919.69 to Wayne Allen Cureton. You'll be required to pay a probation fee of $60 a month, a year analysis fee of $15 a month, and a reimbursement fee of $15. Your total month installments, that is the total amount that you will be required to pay each month, is $197 a month. Will you be able to pay the $197 each month?
Yes, sir.
You will also be required to perform 40 hours of community service. And you will be required to adhere to the other standard terms and conditions of disprobation. Now, Mr. Jones, do you understand the state's offer?
Yes.
You think that the state's offer in your case is fair and just?
I didn't know I had an option to accept jail time. I would have took,
Yeah.
like, I heard you say
No,
90 days.
I'm saying I mean, you would have, okay, the state is offering that you serve 90 days in the Jefferson County Jail, but instead of serving 90 days in the Jefferson County Jail, you will be on probation for 1 year, so you won't have to go to jail.
I would have took the jail, honestly.
You'd rather sit it out?
Yeah, because I mean, I do 90 days. I look at it this way. I do 90 days, I go to jail, I get a 3-for-1. That's 30 days instead of having my whole life drawn out a whole year.
Well,
You know,
if you,
I can relay a separate offer to you. Now, I can't confirm that it's 3-for-1. That's something the jail does separately.
yeah, as long as I get a job. I mean, because I've been through, I know before, if I get a trustee job like in the
Oh,
kitchen.
well,
3-for-1.
let me do this here. I mean, I don't know, if y'all wanna
Your Honor, the state's willing to renegotiate. a
withdraw
separate
that,
offer of jail
okay,
time.
withdraw that, okay. So what they're gonna do, the state's gonna talk to you, and they're gonna withdraw the jail time.
Okay.
Okay,
Okay.
so just go ahead on and just have a seat.
Okay.
That's up to the judge. I
Okay.
can't.
All right, Jefferson County Court at Law number 2 is back in session. Court is in session in cause number 23 CCCR 1942. Case is styled the state of Texas versus Clifford Lawrence Williams Jr. Mr. Williams, is that your full name?
Yes, sir.
Mr. Williams, would you please raise your right hand? Mr. Williams, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Williams, you may put your hand, if you're gonna, Mr., if he's gonna come past the board, he need to put his coat on. Okay, you may put your, no, Mr. Williams, let me do this again. Mr. Williams, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Now, Mr. Williams, I have before me several documents. First document I have is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that is titled Defendant?
Yes, sir.
And are these your initials on the line that state you want to waive your right to an attorney and represent yourself? I also have another document that's titled Waiver of Counsel for Purpose of Inter Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
All right. Now, Mr. Williams, I also have a document that is titled Information Sheet. Tomorrow. I have a document before me that's titled Information Sheet. Do you recognize this? Do you, in this document states that you, Clifford Lawrence Williams Jr., on or about September 3rd of 2023, while you were, hold on, let me make sure if that's right. Yeah, September 3rd of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting search, arrest, or transportation. You understand what you've been charged with?
No, sir.
Resisting arrest, search, or transportation, either one.
You said, or, okay.
I said or, not and.
You said resisting, search and arrest, or. and I
No,
apologize, I
no,
apologize,
it's resisting arrest
Oh,
or search
okay,
or transportation. Do you understand what you have been charged with?
sir.
And to this charge, how do you plead? Guilty, not guilty, or no contest?
Guilty,
Are you pleading guilty freely and voluntarily?
free,
And are you pleading guilty because you are guilty?
yes,
All right. Now, Mr. Williams, I also have before me a document that is titled Misdemeanor Plea Admonishments. You recognize this document?
yes,
On page 2 of this same document, there are a set of initials, 2 sets of initials. First set of initials is below a paragraph that is titled Waiver and is on a line next to a box that's checked guilty. Did you place your initials on this line?
Yeah.
The next set of initials is below a paragraph that's titled Discovery Admonition or Admonishment, and is next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yeah.
On page 3 of the same document, there is a signature above the line that is titled Defendant. Is this your signature?
yes,
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
yes,
Is this your signature on the line that's titled Defendant?
yes,
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
yes,
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yeah.
Now, Mr. Williams, before you sign and initial all of these documents, I showed you these documents first.
yes,
Before you sign all of these documents that I showed you, did you read the documents?
yes,
Did you understand what you read?
yes,
And is everything in these documents true and correct
correct,
to the best of your knowledge?
sir.
Mr. Williams, are you a citizen of the United States?
Yes, sir.
Stand up for stage 1.
Mr. Williams, the state is offering states 1 to be used as evidence in your case. State's exhibit number 1 is the document that has your initials on the two locations on page 2 and your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
They use it.
This is the evidence, this evidence that's stating that you entered a plea of, what was it? Guilty?
Yeah.
And all of the rights that you waived in this, that's stated and that you have waived in this document. Okay, so it's all right for the state to use this document as evidence in your case.
Yes, sir.
Mr. Williams. Is there any evidence that you are currently mentally incompetent to stand trial?
No,
Okay. Mr. Williams, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
For a plea of guilty, the state has offered 1 year
This is
deferred
courthouse.
probation with a $600 fine. Community service has been waived in this case.
Okay.
Right. I don't know why. Oh, yes. You get by and- He's not believing it, but the compliment, no question.
Okay, Mr. Williams. The state is offering that you serve 1 year deferred adjudicated probation. During a 1 year probationary period, you'll be required to pay a fine of $600. You'll be required to pay court costs of $277. You'll also be required to pay a probation fee of $60 a month, a year analysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $163 a month. Will you be able to pay the $163 a month? And the state will be waiving the court costs in this case, and you will be required to adhere to the other standard terms and conditions of your probation.
Okay, now 160,
$163 per month,
whole year,
each month.
and what about the $600 fine?
That's what I did. We added all that up and then we divided it.
Okay.
Okay. So, do you understand the state's offer? Think the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Williams, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to an attorney about a non-disclosure. All right? So, you're gonna stand in front of the court coordinator, follow the directions of the bailiff. Once you finish following her directions, you're free to go, and you have a blessed day. Yes. Jefferson County Code of Law number 2 is back in session. Court is in session and calls number M319-526, case of South State of Texas versus Keita Dewan Jones. Now, Mr. Jones, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
So let me go.
Okay, Mr. Jones, you may put your hand down. Now, Mr. Jones, you have a right to have a record made. That is, you have a right to have a court reporter to sit down and type everything that's being said, or you can waive or give up your right to have a record. In this case, do you waive or give up the right for a record?
Yes, sir, I wait my right.
Okay, now, Mr. Jones, I also have before me a document that is titled Information on my computer. This information alleges that on or about February 24th of 2018, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of theft of services. Mr. Jones, do you understand what you've been charged with?
Yes, sir.
To this charge, how do you plead? Guilty, not guilty, no contest?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, sir, I am.
And are you pleading guilty because you are guilty?
Yes, sir, I am.
Mr. Jones, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir, I do.
On page 2 of the same document, there are 2 sets of initials. First set of initials is below a paragraph that's titled waiver, and it's next to a line that states that has a box checked guilty. Do you place your initials on this document?
Yes, sir, I did.
On the next, the second set of initials is below a paragraph that is titled discovery admonition or admonishment, and it is next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir, I did.
On page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes, sir, it is.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled defendant?
Yes, sir, it is.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir, I do.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I need his waiver, judge's explanation and a waiver.
No.
Thank you. I also have a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes, sir, I
Is
do.
this your signature on the line that's titled defendant?
Yes, sir, it is.
And are these your initials on the line that state you waive your right to an attorney and you desire to represent yourself?
Yes, sir.
And they have another document that's titled waiver of counsel for purpose of entering a guilty plea or proceeding to trial. Do you recognize this document?
Yes, sir, I do.
Is this your signature on the line that's titled defendant?
Yes, sir, it is.
Mr. Jones, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
You done the same with the read?
Absolutely.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir, it is.
Mr. Jones, are you a citizen of the United States?
Yes, sir, I am.
State, I have before me states exhibit number 1. State, would you like to offer states 1 in evidence?
Yes, Jim.
Mr. Jones, I have before me states exhibit number 1. States number 1 is the document that you acknowledge. This document also have your signatures on these 2 locations.
Okay.
And your initials on those 2 locations on page 2 and your signature on page 3. State would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes, sir, it is.
Mr. Jones, is there any evidence that you're currently mentally incompetent to stand trial?
None, Your Honor.
Mr. Jones, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Judge.
And what is the agreement?
In exchange for the defendant's plea of guilty, the state has offered 90 days in Jefferson County Jail, giving credit for 2 days. And he has to turn himself in on June the 18th, 2024, on or before 6 p.m. And also court costs was included.
Okay, Mr. Jones, the state is offering that you serve 90 days in the Jefferson County Jail. You'll be given credit for the 2 days that you've already served. The court cost in this case is $377. Will you be able to pay the $377 court cost?
Yes, sir.
Now, Mr. Jones, do you understand Mr. Jones, your jail time is to begin on June 18th of 2024 at or before 6 p.m. Mr. Jones, do you understand the state's offer?
Yes, sir, I do.
Do you think that the state's offer in your case is fair and just?
Yes, sir, I do.
And do you accept the state's offer?
Yes, sir, I accept.
Mr. Jones, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Jones, this will conclude your case. You're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you will be free to go and you have a blessed day. And you need to bring that paperwork with you when you report to the jail,
Yes, sir.
okay?
Thank you, Your Honor.
Okay, you are. Okay. Okay. Court will now proceed with the bond forfeitures in cause number, first case is cause number 23 CCCR 1880, case is styled the state of Texas versus Jamard K. Anderson. Jamard K. Anderson was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court bailiff called the name of Jamard Anderson at the courthouse door. Jamard Anderson did not answer. Jamard Anderson has not appeared in court since the court has been in session. The time now is 1:35 p.m. on today's date. Ms. Bailiff, would you please call the name of Jamard Anderson at the courthouse door? Jamard Anderson's name was just called again at the courthouse door, but Jamard Anderson did not answer. The reasonable time has passed to give Mr. Anderson an opportunity to appear in court. Is not appearing to a state. Do you have a motion?
Statement for bond forfeiture.
That motion will be granted. Jamard Anderson bond will be forfeited and warrant shall be issued for his arrest in cause number 23 CCCR 1880. Next case is cause number 24 CCCR 0526. Case is styled the state of Texas versus Jonathan Brezino. Jonathan Brezino was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Jonathan Brezino at the courthouse door. Jonathan Brezino did not answer. Jonathan Brezino has not appeared in court since the court has been in session. The time now is 1:36 p.m. on today's date of May 21st of 2024. Ms. Bailiff, would you please call the name of Jonathan Brezino at the courthouse door? Jonathan Brezino's name was just called again at the courthouse door by the court's bailiff. Jonathan Brezino did not answer. A reasonable time has passed to give Mr. Brezino an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Statement for bond forfeiture.
That motion will be granted. Jonathan Brezino's bond will be forfeited in cause number 24 CCCR 0526. Next case, we have 2 cases. Both are styled the state of Texas versus Arturo Hernandez. Arturo Hernandez has cause number 23 CCCR 1902 and cause number 23 CCCR 1919. Arturo Hernandez was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Arturo Hernandez, Arturo Hernandez did not answer. Arturo Hernandez has not appeared in court since the court have been in session. The time now is 1:38 PM on today's date of May 21st of 2024. Ms. Bailiff, would you please call the name of Arturo Hernandez? Arturo. Arturo Hernandez's name was just called at the courthouse door. Arturo Hernandez did not answer. Arturo Hernandez has not appeared in court since the court has been in session. A reasonable time has passed to give Mr. Hernandez an opportunity to appear in court. He's not appearing in court. State, do you have a motion? Arturo Hernandez bonds will be forfeited in both cases, cause numbers 23 CCCR 1902, cause number 23 CCCR 1919, and a warrant should be issued for his arrest in each one of the cases. State's motion is granted. That's it. I think that's it. And this will conclude the calling of the court's arraignment docket on on May 21st of 2024 in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day. Prosecute, Mr. Prosecutor.